That and more here on Top Story, brought to you by Vodafone. The future is exciting ready. Bill Aqua Mineral Water and Gasim, the nation builder. And tonight, the push by the NDC's 2020 presidential candidate John Mahama for a runoff between himself and President Akufo-Addo has been shut down almost 3 months after he decided to challenge the election outcome. The Supreme Court today ruled that no credible evidence has been adduced in the course of the trial to support the claim that no candidate won the election. Following the declaration of Nana Akufo-Addo as winner of the 2020 polls, Mr. Mahama described the results as fictionalized and headed to court. Well, today, the court settled the matter.
The petitioner has not produced any evidence to rebut the presumption created by the publication of CI 135, for which his action must fail. We have therefore no reason to order a rerun as prayed by the petitioner as in relief F. We accordingly dismiss the petition as having no merit.
Well, so that was the decision of the court today. But court correspondent Joseph Akable joins me in studio with sat through the entire petition from start till date, and we have the final judgment today. First, Joseph, the court assessed the evidence brought by Mr. Mahama's witnesses and said some were not relevant. Walk us through them.
In fact, they described Mr. Esiedun Nketiah as the star witness, in that his testimony explained why the petitioner decided to bring the matter to court. With regards to Roger Metununu and Dr. Michael Pesa-White, the court took the view that their testimonies did not speak directly to the matter, and they also made reference to the fact that they recounted a fanciful tale referring to this narrative about being instructed or being asked by the EC chairperson to go and confer with the presidential candidate. It was during that conference that the declaration of the results was carried out.
The one whose testimony appeared to have some relevance to the issues at stake was Mr. Johnson Esiedun Nketiah. He was, in fact, the star witness of the petitioner. His testimony vividly explained the reasons why the petitioner is in court. As for the other two witnesses, that is PW2 and 3, Dr. Pesa-White and Mr. Robert Joseph Metununu, the little said about their testimonies relative to the issue at stake, the better. They recounted a fanciful tale of how the chairperson refused to heed their complaints on some irregularities they noticed in some of the coalition forms that came from some of the regions. We described this evidence as fanciful because despite this alleged protest, they went ahead to verify and certify 13 out of the 16 election regional coalition seats. They did not give any indication as to how these happenings and the absence affected the final results announced by the first respondent. Having signed or certified these forms, the witnesses, particularly PW3, cannot turn around to talk of irregularities in the said forms. Their testimonies would have carried some little weight if the purpose of the petition was to challenge entries made on the coalition forms or summary sheets, but that is not the case. Their testimonies were therefore of no relevance whatsoever to the issues set down for determination, and we found them unworthy for any consideration whatsoever in the settlement of the issues. In fact, regarding the testimonies of PW2 and PW3, if their evidence is to be believed, then they have to blame themselves for abandoning their post at the National Coalition Center at the time the verification and certification of the results were ongoing, and PW3 had then verified and certified 13 regional coalition results out of the 6.
So that's the court's perspective on the two witnesses out of the three that the petitioner presented. But tell us about how it concluded on the issues that is set for trial.
And so it concluded by first dealing with the initial objection that was raised by the respondents. You recall the respondents had actually said that the court should even dismiss the case without it going for a full trial. And so the court dealt with that related to issue one, whether or not the petition disclosed any reasonable course of action. The court took the view that because of the nature of the case, it is alleging a breach of a constitutional provision. The court said for such a statement to be made or for such an allegation to be made, it cannot be said to be frivolous false or vexatious. And in such allegation needs to be examined in the way of evidence, and that requires that a full trial takes place. And so the court took the view that the petition discloses a reasonable cause of action. The second issue the court dealt with, and in terms of the remaining issues, the court dealt specifically related to Mr. Siedu Nketiah's testimony and the cross-examination that was done mainly by Mr. Kotampa and in some instances by the lawyer for the first respondent. The question that the court was to answer was whether or not the data contained in the declaration of the first respondent on December 9, whether President Akufo-Addo got more than 50% of the votes cast. The court, by relying on the cross-examination of Mr. Siedu Nketiah by Mr. Kotampa, concluded that it is absolutely clear that the EC chairperson, in announcing the results, erroneously mentioned 13.4 million as the total valid votes cast. The court said that the testimony of Mr. Siedu Nketiah confirmed that the correct figure is 13.1 million. And using that correct figure to calculate, it indicates that President Akufo-Addo crossed the 50% mark. And that 50% mark did not have the Techiman South constituency results. And so on the issue 3, which is the question about whether or not the inclusion or exclusion of Techiman South constituency results, Mr. Akufo-Addo crossed the 50% mark. So the court had dealt with the fact that the first one did not include Techiman South. So it had answered one part of the issue already. The other part of the issue was to include the Techiman South. The court said that at the time the petition was filed, the results from Techiman South were available. So it took the results, added what Mr. Mahama obtained, added that of Mr. Akufo-Addo, and added both to the total valid votes cast, and did a calculation which indicated that Mr. Akufo-Addo got more than 50% of the votes cast, i.e. answering the third question that he met the threshold with the inclusion or exclusion of the Techiman South constituency results. On the fourth issue about whether the declaration breached the constitution, the court disagreed and said that the petitioner had not adduced any evidence to point out that that declaration was contrary to law. Then the fifth issue had to do with that of vote pardon and errors that were detected. You recall that Mr. Mahama's lawyers had said and even indicated in the petition that some 5,662 votes in 32 constituencies, which they described as samples. Eventually, Mr. Siedu Nketiah filed his witness statement. He made reference to 26 constituencies, which he attached some summary sheets. The court said that the evidence does not prove the allegation, and that the expectation would have been that because he was talking about computations which led to the vote pardon, it would have helped their case if he had brought the pink sheets from the polling stations within these 26 constituencies to justify or prove that indeed vote pardon took place. The court said nonetheless it proceeded to look at whether or not, if it is true and had been proved, it had any impact on the outcome of the results. It made reference to Mr. Siedu Nketiah's cross-examination by Mr. Kotampa yet again, and said that Mr. Siedu Nketiah was being evasive in not admitting to the fact that 5,662 votes per the 6.7 and 6.2 million obtained by the two leading candidates was insignificant. And so the court took the view that, one, the vote pardon allegation and error had not been proved, and also two, even if it had been proved, it didn't have any material effect on the outcome of the election. So that's how the court settled the 5 issues.
5 issues. Well, I'll be talking about the reactions from the legal teams right after that ruling, but I'm interested in what transpired in the court itself, the reactions whilst the judgment was being delivered by Justice Kwesi Enyinyewa.
It was a case of a lot of the parties taking notes. I mean, we thought it was only the president who was taking notes. Everyone was taking notes. From Mr. Chikata, I saw him with a pen and paper writing. I saw Mr. Mahama, he was sitting there. He wasn't taking notes, but he was seated quite calmly. There were moments in the course of the justice reading the judgment that he was touching his jacket, adjusting it. I saw him adjust his mask as a point and hold his chin also in between. In terms of the respondents' lawyers, do the same thing. They were also taking notes, copious notes, I must say, especially Mr. Frank Davis, who eventually addressed us after proceedings, was also taking a lot of notes. When the justices had finished ruling, so mostly what happens is when they are done with the judgment, they now could proceed to give subsequent orders if necessary. When they had finished the main judgment, Mr. Chikata stood up and said, as the court pleases. Then the others also waited. Then the court now said that it makes no order as to cost. It was at that point that the respondents' lawyers, Mr. Kotampa and Justin Amenivo, came in to thank the court for its decision and also commended the staff of the Judicial Service for how they had assisted in terms of the proceedings. So that is how things panned out in the courtroom.
Okay, so I've heard about the petitioner and his reactions during the delivery of the judgment. How about Madame Jean Mensah and the other, commissioners of the Electoral Commission? What was the reaction?
They were quite calm all throughout. I mean, I didn't see them jubilate at any point or show any sign that they were celebrating. They were quite calm all throughout. Immediately, the judgment was rendered. They moved slowly and quietly out of the courtroom and left the premises of the Supreme Court.
Okay.
The second respondent's legal team, i.e., President Akufado's side, when the case ended, I don't know where the handkerchiefs came from, but all of them had a particular type of white handkerchief, which all of a sudden they brought out and they were waving it around. They were waving it around
In the court?
outside the courtroom,
Okay.
at the entrance of the courtroom, where they took photographs, singing songs that the will of God has been done, and dancing at the entrance. And in some instances, the lead counsel, Mr. Kotampao, was chanting Chobe, and they were responding as well. And so it was more of like a lot of celebration after the decision had been given for the side of the second respondent.
Did we have supporters massing up in the court?
No, because of the way the security arrangement is, getting access to the courtroom itself, the court premises, it's difficult. So we didn't see supporters come over to the court premises.
Okay, so now let's talk about reactions from the legal teams, like we always get.
This time around, Mr. Mohammed's side, in fact, they had indicated to us prior to going in for the judgment that they were going to speak to us at 5 p.m. That's what they told us. And so at the close of proceedings, Mr. Amaliba, who is the director of legal at the NDC headquarters, came over and announced in the microphone that they used to address us that indeed they are going to speak to us at 5 p.m. We have
And that
subsequently
time has
seen
changed, yeah.
another notice that indicates that it's at 6 p.m. But Frank Davis, who you recall at the start of the proceedings, he was the one who was addressing the news conferences, but the
So he
court
was cautioned
made
by
an
the
issue
court.
about the fact that he was a lawyer on record and the case was still pending. He took the opportunity to address us. He had quite an interesting summary of how truth has been told.
The verdict of our Lord Justices of the Supreme Court has been held in cold print by an unanimous decision of 7 justices of the Supreme Court. And I want to say, for the purposes of emphasis, that no matter the sartorial elegance or glamorously attired and adorned, a provocative misrepresentation of the correct legal position is the naked truth. And I repeat, the naked truth shall always prevail, as loudly pronounced by the highest court of the land. Need I say, the battle is still the Lord's. Thank you.
So that's lawyer Frank Davis there, the reaction from the legal team of the second respondent. Well, Joseph, your work is done as far as the election petition 2020.
We don't know yet.
You
I
don't
mean,
know
there's
yet.
an option of a
Exactly.
review.
I was going to
and so,
ask whether
yes,
that happened, because we always get it right after the ruling.
there's an option of a review. That is if Mr. Mohammed's side decides to. And that is how come a lot of people are looking forward to what Mr. Mohammed will be saying this evening. You recall in 2012, 2013, after the decision, then Mr. Akufo-Addo, who was the petitioner, indicated to the whole nation that he disagrees, but he doesn't intend to file for a review of that decision and accept the result, the outcome of the court case. And so it remains to be seen whether my work is done or not.
Okay.
I mean, unless we hear from
I'm hoping that
Mr.
your
Brown.
work is done, but we look forward to your account in writing of everything that has happened so far. We look forward to that book from Joseph Akable, our court correspondent. Thank you very much, Joseph. Good job done. But I'll cross over to the NPP headquarters. I told you earlier that supporters were already converging and jubilating.
Official beginning of the celebration TP has secured in court. And as you heard the party chairman say just a brief while ago, that the rule.
So that's the mood at the NPP headquarters earlier. My colleague Manuel Cranting was there. He's back in the studios. So tell us about the situation there. Quite chaotic.
Well, chaotic you may say, but it was spontaneous jubilation really at the headquarters of the New Patriotic Party. In fact, I was there before the end of the verdict that was being delivered by Chief Justice Kwesi Nyaboa, and right after he was done, the entire premises, all the party functionaries who were there, went up jubilating. In fact, everybody who I saw at the party headquarters who really was a member of the party was clad in white. They had T-shirts printed on them, victory, and they had printed a poster which had and still President Nana Akufo-Addo, with a picture of His Excellency the President Akufo-Addo on it. And so you had some level of jubilation there. You had the leadership of the party, starting from the Chairman Freddie Blay himself, the General Secretary John Boedu, and then the national organizer Sami Oku, all addressing the supporters who had thronged the premises to jubilate with them. Indeed, they made a point, and John Boedu made that point quite forcefully, that the entire petition was a waste of time of Ghanaians, and for them, they knew that right from the get-go when the petition was filed at the Supreme Court, they knew it was not going to amount to anything, and that was vindicated when the Supreme Court gave that ruling today.
Okay, so earlier, before you went to the NPP headquarters, you passed through the NDC headquarters. What did you find?
Well, the mood was somber, and really everybody who was there was keenly monitoring the proceedings from the court as everybody watched on TV. That was it. We're not allowed to film in there. We're not allowed to speak to anybody. We're told that the party had designated people who were going to speak. And as you saw, Sami Jemfi address the public after the ruling was given. And so the picture at the NDC's headquarters was quite the opposite of what you saw and what we saw at the NPP's headquarters.
Thank you very much, Manuel Cranting. There earlier today, we also told that the president is set to meet with members of his legal team at the top of the hour 5. And my colleague Elton Broby, our presidential affairs correspondent, has been monitoring events. He joins us on the line. So, Elton, what's the situation at the Jubilee House? Give us an update on that meeting between the president and his legal team. Hello, Elton. Hello, Elton. Okay, it appears that we don't have Elton Broby there on the phone just yet, but we'll check again and see if we have Elton Broby. My colleague Maxwell Agbegba is already at the cantonment office of Mr. Mahama, and we'll be crossing over to him also on the very latest, because we're expecting that official address and his response to the Supreme Court's decision today, and we'll bring you live proceedings on that live on Joy 99.7 FM, on Joy News. And I'm told Maxwell Agbegba has joined us on the phone. Maxwell, what's the situation at Mr. Mahama's office? Okay, so we don't have Maxwell Agbegba just yet, but let me take you to Parliament, where there's been some reaction from Parliament as well, and correspondent Kwesi Parker Wilson joins us live. Parker, what's been the reaction amongst members of Parliament?
Specifically for the minority in Parliament, they describe the verdict as unfortunate and disappointed. They are also quick to add that they are not surprised, though, because judging from the turn of events right from the start of the election petition, they knew that the outcome wasn't going to be different than what they've been handed this morning. But then they are asking their party supporters to remain calm and also be vigilant going forward into 2024, because they know that going to the courts isn't the best way to resolve electoral matters, but rather being vigilant at the polling station, at the collation centers, are the right way to go. And some of them even said that June Mensah, the chairperson of the Electoral Commission, essentially was being protected by the Apex Court, and that is why they believe that they prevented her from mounting the witness box to testify as far as this petition is concerned. We can speak to those I spoke to.
But of course, I am not surprised. I'm not surprised because you could see the trend of events from day one. And so for some of us, we knew that the outcome was not going to be different from what has been handed us this morning.
But why then didn't you abandon the whole petition if you knew the outcome even before the judgment?
You know, prospective will judge us. We have demonstrated clearly that we are law-abiding people, and that when there are issues like this, we go to court, trusting that the court will give us justice. At the end of the day, the whole world has seen what has happened. Africa has seen what has happened. Ghanaians have seen what has happened. And for us, it's very important. The grassroots, I want to encourage them that we have learned our lessons from this, and that 2024, let's stand up, let's be vigilant, let's ensure that we win and win massively, so that we don't even think of going to the courts. Because for me, as it stands now, Going to court is a different thing altogether.
So what really are the specifics of the lessons you've learned as far as this petition is concerned going forward into 2024?
I don't want to sort of pass judgment on what the judges have said, but I think that it's a problem with the judgments. And so if this is the way it's going to continue, then you want to look at a different way of solving issues rather than going to the court.
Like how?
That I leave to myself.
Different way of solving issues like how?
That I leave to myself.
I mean, resort to demonstration,
I
protest,
leave that to myself.
I think it's an unfortunate decision for the NDC. And when I looked at the proceedings right from the beginning,
right,
I'm not surprised.
You're not surprised?
I'm not surprised. I'm not surprised because I had the opportunity to follow it, and I followed it. Look at how many times petitions by our lawyer, Chachu Chiketa, were dismissed all over.
No, but it was a matter of law. I mean, the point of law, if it's not grounded in law, the judges would deny your application.
Well,
and that is what happened.
Well, I don't think that it was all grounded in law.
So some reactions there from the NDC members of parliament interacting with my colleague Kwesi Parker-Wilson. We had the MP for Bole, Yusuf Suleiman, of course, Dr. Oko Vanderpoy as well. Presidential Affairs correspondent Elton Brobe joins us back on the phone. Elton, so earlier you mentioned that lawyers for the president will be there to officially update him on the decision of the court. Has that happened?
So for the meeting is still ongoing. It's unclear whether after the meeting there will be some comments from President Akufo-Addo on the election petition and the judgment that the court came to. It's very unclear whether that will happen. The meeting is behind closed doors. We are not privy to what is being discussed inside, but what I know for sure is that the lawyers are here at the Jubilee House to formally tell President Akufo-Addo that he gave them a task to defend him in the election petition. The judgment is out, and the president is on the victory side. And then President Akufo-Addo will thank them. And then fleeing from that, my information that there's going to be some broadcast, but we are unclear as to how this will go and whether it will come off, whether it will come off at all. We are also been trying to get information whether there's been a formal concession from former President John Mahama. My information that has not been done as of now, and that the presidency is hoping that such a call will come through for the former president to formally concede. Now that the Supreme Court has affirmed the decision of the Electoral Commission on the 9th of December 2020. But here at the Jubilee House, it was business as usual. In the morning, it was a rehearsal for the Independence Day parade, which will take place at the foyer of the Jubilee House on Saturday. President Akufo-Addo himself came to the office around 10:30. At the time the judgment was being read by the president of the court, Kwesi Enin-Yeboah. Now, when he entered his office, the vice president accompanied him there, and then they watched the proceedings on television. When it was all done and dusted, and the judgment went this way, then the congratulations started from the vice president. Some office secretariat all went in to congratulate the president. And then after that, he started meeting people that had been penciled on his itinerary for today. First was the Nigerian ambassador to Ghana, who is leaving the country after his duty tour. And then after, he met with the local organizing committee for the 13th All Africa Games, which will be held in Ghana. And as I speak, he is so in a closed-door session with members of his legal team, talking about the outcome of the election petition.
Keep monitoring that, and that's Presidential Affairs correspondent Elton Brobe on what the president has been up to following that Supreme Court decision. Former President John Dramani Mahama, the petitioner in this case, is all set to address the media. As and when we get the signal, we'll take you live there. But meanwhile, lawyer Martin Pibu joins us on the line. For those of you who still are trying to make sense of today's ruling, he joins us with some help. So what should we know? What are the takeaways from today? We know that it was dismissed, lacking merit, but what more should we know in terms of the layperson?
Okay, so Emefa, the thing about it, the main thing, of course, apart from lacking merit, the first thing to say, in other words, is that it means now no more challenge. There's no longer any challenge to the president's legitimacy, right? So if he doesn't have any sword hanging around his neck, okay, that apart, the next thing is that looking at this decision, you would see that at least we've gotten it right the second time. I mean, looking at the 2012 petition and then now 2020, we are adding to our credentials, right? Now, when it comes to the judgment itself, in terms of the content, when it comes to the evidence of the petitioner's witnesses, you would see that the court mentioned that the evidence didn't go far enough at all. Well, the point you should note is that this is not new, okay? The same thing happened in 2012. In actual fact, I should read you a short passage from the 2012 judgment at page 495, what Justice Akuto Banfo said. Listen, he says, I must say that the pieces of evidence offered by both Mr. Johnson and Edun Ketia, who gave evidence for the first and third respondents, and Dr. Afarijan, the chairman of the Electoral Commission, shredded into pieces the petitioner's case under this head. It became evident that Dr. Bawumia was not too familiar with the processes and procedures leading to the conduct of the presidential election. You see it? So today, when you hear the court saying, Edun Ketia didn't cut master, he had a poor showing, you see how the tables have turned. In 2012, he was the star. He shredded Dr. Baumia's evidence. You see, yeah, so these are some of the things. It tells you that today your evidence may be good and you can win in court, but tomorrow it may not be that good.
Okay. So there were no consequential orders, Mr. Kwebu. Is it because the case was dismissed?
That's correct. So basically, Mr. Mahama wanted a runoff. So to get a runoff, the court would have had to come to a conclusion that, yes, nobody crossed the 50+1 mark. So to the extent that he couldn't prove that case, that's how come there was no consequential order for a runoff.
So we're expecting Mr. John Dramani Mahama to address the media in some few minutes. But what do you expect? Do you see a grounds for a review? Yesterday you mentioned that you're not hoping that will happen. But what are your expectations?
Yes, I'm still standing at the same position. I don't think that it's a case that he should go and review. You see, we keep saying something that he's won a lot. He and his lawyers, they've done a lot. They've courted and gained a lot of public sympathy, especially on the matter of Madame Mensah not mounting the stand. You see, so they should. It's okay. There comes a point where you have to leave the stage when the applaud is loudest. Don't go do certain things that will mar everything that is achieved. I think the pinnacle of the case for the Mr. Mahama was when the court refused to allow Madame Mensah to take the stand. So Mr. Mahama shouldn't do too many things beyond that. Otherwise, something may come up and then he rather will now become the center of attention. When right now it's Mrs. Mensah who is the center of attention on the fact that she didn't mount the stand, as Dr. Farijan did.
Okay, I would have to rudely interrupt you, Mr. Martin Kwebu. Thank you so much. He's a lawyer helping us understand. But I take you to the cantonment office of John Dramani Mahama as he addresses the media.
I understood what was happening, even if the legal technologies were not all